I'm starting. Thank you everyone for joining on time. So we would like to show you and explain you what is a will and why do you need to have one, what is the importance of it, and this is a webinar. We are a legal tech startup. We help individuals with their estate planning needs. This is one of our first webinar we're hosting. I hope this is useful. You will get a lot of valuable information. Vaishnavi is my co-founder. She's an expert in legal domain. So she will be taking care of the presentation. But just before we start the presentation, I have a couple of things to run. So Vaishnavi, can you go to the next slide? So as I mentioned, you do have chat where you can raise any kind of concerns about the audio quality, video quality, any kind of issues, or if you just want to generally add some comment perspective. But if you have specific questions, please put them in the question and answers section so that we don't lose track of it. We want to answer all of your questions through the presentation as well as after the presentation when Q&A happens. We will provide you access to audio if at all you have a follow-up questions. If you raise a question and if that is answered, but you still have a follow-up question, you can raise your hand and I will enable the audio. Because this is being done in a webinar format, all of you are in the here only kind of mode. Use gestures if you need any help from me. Okay, and I will be monitoring chat and Q&A both. And I have also set some polls. This polls is just to understand the audience. And all of these answers are anonymous. We wouldn't be storing these into the recordings or anything. This is just to understand audience polls. So I'm launching these polls. I hope you can see the polls tab. If you see, I just want to understand your age range. If you can submit your votes. Similarly, I would like to know the city where you're from. And not exact salary, I'm just asking a salary range to understand about you in a better way. And if you already have a term insurance plan or not. These are the 4 questions. These are launched from the polls. You could definitely answer them. Do answer them so that we can see the results. This will help us in curating the content in a better way. Okay. Yeah. I wouldn't be publishing this result for all. This will be just for us. Yeah. Okay. Yes, I think we can go back to the presentation, Vaishnavi. Yeah.
Yes.
Yes.
So, good evening, everyone. Today, we all have gathered here to discuss a very important topic, which is wills and why do we need to have one. Before going into detail about what exactly a will is, I would like to start with a term which is instruments. What exactly is an instrument? So, a instrument is a legal document which expressly specifies what legal rights are enforceable, what duties are enforceable, what obligations or interests are enforceable. To put to you all in very simple words, in legal language, we call a legal document an instrument. Now, these instruments are primarily of 2 types. Number 1, non-testamentary instrument, and number 2, testamentary instruments. Now, what is the difference between these two? When we talk about non-testamentary instrument, it is that which takes effect during the lifetime of a person. To say it comes into operation when an individual is alive. For example, When we sign a contract, it comes into operation immediately. And likewise, when we sign a sale deed, it comes into operation immediately. Whereas, on the other hand, we have testamentary instruments which come into operation only upon the death of an individual. For example, a will. A will comes into being or takes effect only upon the death of an individual. Moving further, we would be first discussing some important terminologies that are related to a will. First of all is testator and testatrix. So, a male who makes his will is known as a testator, whereas a female who makes her will is known as an testatrix. Second, most important term in terms of a will is executor. Now, who is an executor? Executor is a person who is responsible for disposing of the assets of the testator as per his will. So, executor is a person who is named by the testator in the will, who, after the death of the testator, would be going to the court to obtain the probate for the will, and then he would be disposing of the assets of the testator according to his wishes. Third important term is beneficiary. A beneficiary is actually a person who will, in essence, inherit or will succeed to the property of a testator under a will. This beneficiary would be the person who would actually become the owner of the property once a person passes away. And this beneficiary would be named by the testator in the will. Then we have another important person who is a nominee. Nominee is actually a person who temporarily holds these assets while the beneficiary is established. So we have a bank account. We name a person as a nominee in that bank account. This nominee would temporarily hold the money which is there in the bank account. Once the executor would go to the court and obtain the probate for the will, this nominee will give way to the beneficiary, and the beneficiary would be the person who would actually get the money upon inheritance. Now, let us come to the main topic as to what exactly is a will. So, a will is defined under Section 2, Clause H of the Indian Succession Act 1925. To put it simply, a will is a document or legal instrument which is prepared by the testator during his lifetime, which specifies how he wants his assets or properties to be inherited or disposed of after his death. To put it simply, it is a document which a person prepares during his life, and in that document, he specifies who would be the person who would be inheriting these assets once he is no more. There are three essentials when it comes to a will. First one is a will should be a legal declaration, which means a will should be properly drafted. It should be executed by the testator, which means it should be properly signed by the testator, and then it should be attested by at least two witnesses. Second one is a testator should make these declarations with respect to his property. He cannot simply assign a person as an executor and say that I transfer my entire property to so and so person. He should be very specific what all properties he has and what all properties he wants to transfer to whom all persons. He should be very specific. The wordings of the will should be very clear, and there should not be any ambiguity. The third most essential thing is that this declaration or this will come into effect only after the demise of the testator. Therefore, it is a testamentary document. It has no value, or it will not come into operation in during the lifetime of the person. It is a testamentary instrument which will come into operation only upon the demise of the testator. Now, the second most important question is, who is competent to make a will? Who all can make a will? There are two conditions. First, a person should be a major. That is, he should be of the age of 18 years or above. And second, he should be of sound mind. What does sound mind mean? That he should be a person who is capable of taking rational decisions in a reasonable situation. Now, another important question which comes up is, can a person who is, say, deaf and dumb or maybe blind, can such people make a will? So, the answer is yes, provided they are able to understand what they are doing by making a will. They know what consequences a will would have. In such a case, these people are also competent to make a will. Now, sometimes it is debated that people who are insane or maybe intoxicated or maybe terminally ill people, they are barred from making a will. Especially when it comes to terminally ill people who are on deathbed, it is sometimes said that these people, they are incompetent to make a will. Here, there is a test which is sound testamentary capacity. We have to check whether the conditions of these tests are satisfied, and in that case, these people also become eligible to make a will. In short, I will explain what this test is. If the person who is making a will is able to understand what all properties are there within his domain, what all properties he is an owner of, and if that person is also able to understand which properties he wants to give to which individual and which individual he wants to uh, deny those properties to, and he is able to understand that by making a will he would be actually disposing of his assets after his demise to so and so person. If he is, we can say, if he is of sound mind, if he is capable of taking these rational decisions, if he is able to understand by making a will what all he is doing, then even if such a person is on deathbed, then in that case also such a person is very much capable of making a will. Next question which comes up is, how does one make a valid will? So I have divided this into three stages. First is drafting. When you draft a will, the language should be very clear and it should not be ambiguous at all. The language should convey what all properties you want to give to which person. It should be crystal clear. There should not be any doubt about the same. Second is execution, which is talked about in section 63 of the Indian Succession Act 1925, which says that the will should be signed by the testator. Or if he cannot sign, then he must put on some mark on the document signifying that he is making this will voluntarily and there is no force or fraud upon him to make such a will. He is making this will of his own wish, free wish. And third is attestation. While the person who is actually signing the will, when he is actually signing it, there should be two persons who should have witnessed this event, and they should specify that yes, they have seen the testator sign out of his free will on the will document, and they should also countersign the will document, And it is not necessary that these two people should actually know what is written in the will. Only they should witness this process of the testator signing the will. Also, there is an important question: should these two people who are witnessing, should they be present at the same time while the testator is signing the will document? So the answer is no. One could be present and the other one could come on later on, and the testator could signify to the person who comes later on that yes, these are his signature, and that he has signed his will out of his own voluntary wish. In that case also, the person coming later on can sign the document as a attesting witness. So minimum two attesting witnesses should be there to witness this entire procedure. Now, another very important question which comes up is whether registration of a will is compulsory. So, no, registration of a will is not at all compulsory. It is optional under Section 18, Clause E of the Registration Act 1908. However, as legal professionals, we always recommend to have your will registered because it provides authenticity to the will. And it is always easy to prove a will that is registered in the office of the nearest sub registrar. Now, we had a question as well whether a will can be revoked or not. So, yes, a will can be very well revoked n number of times during the lifetime of the testator. This is given under Section 62 of the Indian Succession Act 1925. So, you can write your will as many times as possible, provided you revoke your already written will. Just when you're writing your new will, a sentence is written in the same will that I hereby revoke all my previous wills and testaments. This sentence revokes your earlier wills. However, if you want to revoke only a part of a will, in that case, there is no need to revoke an earlier will entirely and make a new will. You can use a codicil in which we write that we want to revoke so and so part, and this would be the document. This is helpful when, say, you have made a will and you dispose of some property from the will, so that property is no longer under your control. In that case, we can simply make a codicil and remove that part from the will, while the entire will that was already written stands still. Also, another question which is there is, can you revive a revoked will? Can you bring to life a will which has been revoked? So the answer is no. You cannot revive a revoked will. In that case, you have to rewrite another will. So a will can be revoked n number of times, any number of times during the lifetime of the testator. Now, why is it we are talking from the beginning, make a will, make a will, make a will? Why is it very important to make a will? The first reason could be the unpredictability of life. Our life is very uncertain. None of us could predict the advent of coronavirus. None of us could simply say that we'll be able to breathe our next breath. So, this uncertainty of life actually is a very big reason why we need to make a will now. Second is, making a will protects our family from future legal disputes. We do not want to leave our family in limbo when we are no more. We want to protect them. We want to tell them what all we have. We want to distribute our assets amongst our family members while we are still here. If you remember, when Mr. Dhirubhai Ambani passed away, there was a huge dispute between the two brothers, Mr. Mukesh Ambani and Mr. Anil Ambani. It was because Dhirubhai Ambani died without a will. And there was a feud in the family as to which of the brothers would be succeeding to which of the businesses. And then ultimately their mother had to come in between and mediate. So these all bitter relationships these all bitter things could have been avoided if Mr. Dhirubhai Ambani would have made a will during his lifetime. Also, if you make a will, you can appoint an executor according to your wish. This executor you can appoint on the basis of the person you trust, whom you know, that who is capable and has the capacity to manage your assets when you are no more, who you think would be trustworthy to go to the court and take probate and then dispose of your assets to your beneficiaries according to your wishes. So this appointment of executor is also in your hands. Once you are no more and you do not have a will, this executor would be appointed by the court, and he may not be the same person whom you would have wanted to be the executor. Very important reason to make a will is that you have an option to choose guardians for your minor children. In case you do not have a will, these minor children's, God forbid, if anything is to happen to you, the future of these minor children would ultimately be then decided by the law courts, and they would be then put into legal custody, or they would be given to those guardians who may not be capable enough to look after them according to your wishes, how you would have taken care of them. So it is always essential, it is always necessary, it is always recommended to choose a guardian for your minor children and name such guardian in a will, so that your children could be well taken care of once you are no more there. Also, you can distinguish between a beneficiary and a nominee in case of a will. We always nominate a person in a bank account, but we may not be wanting that person to inherit our property when we are no longer there. So, in that case, once you have a will, you can easily distinguish between a beneficiary and a nominee. And you have lived a complete life, you have lived a full life. Also, you may be wanting to leave a legacy, you may be wanting to leave a part of your assets to some charitable organization, or if you are an animal lover, you may be wanting to leave some assets for the care of your pet animals, just like Mr. Ratan Tata did for his dogs. So in that case, if you want something like this, if you want your assets to be protected, if you want to live a stress free life, if you want to leave a legacy on the sands of time, it is highly recommended that you make a will. Now we would be debunking some common myths and misconceptions when we are talking about wills. One of the very common um, myth is that I do not own a lot, so I need not make a will. Will is not only for distribution of your assets. Will is also there for leaving a legacy, for protecting your legacy, and for also caring for your minor children. All these provisions you can easily include in your will. These things could be easily taken care of when you are making a will. Also, we often say that I do not want to make a will because my family already knows what I have. In that case, I would like to say that good, that your family already knows what all assets and possessions you have. But once you are no more there, there could arise a feud between the family where uh, two or more persons could be fighting to inherit the same possession of a property or land. In that case, once you are already here, why not settle everything and give that mental peace to your family? Third one is I need not appoint a guardian for my minor children because my family will look after them if I am gone. This is also a very incorrect view, because once a person is not there, these children would actually go into court custody, and then the court will decide who would be the guardian for these children. And the guardian that the court would appoint may not be the same person whom you would have wanted to be. You would have wanted a guardian who would have provided your children with good education, good health, good food. But in that case, this opportunity to appoint the guardian would be shifted from your hands in the uh, hands of the court, and the person who would be appointed the guardian by the court may not be the same person who you would have chosen. Also, often there is a misconception that writing a will is very cumbersome process, it is very expensive and time consuming. In today's digital world, I can say that there are various platforms which provide you this service at a very reasonable cost and in a very time bound manner. You just have to follow some steps, and this thing can be easily taken care of. You are insured is one such platform. Also, it is said that you always have to register your will at the office of the registrar for it to be legal. This concept is also very wrong, because a will is as much legal even if it is unregistered. We recommend getting it registered just to provide it some authenticity and to provide it that weightage, so that no one could come up once you are no more to uh, say that this is not a valid will. No one can contest that will once it is registered in the office of the registrar. Therefore, it is recommended. Even if you do not want to get it registered, it is good enough to be legal. Also, there is a misconception that I am too young, nothing would happen to me. Why should I write a will? So, like we already discussed, that life is very unpredictable. We do not know what will happen to us the next minute. So, it is always recommended to have a will in place. Also, there is a misconception that one cannot change or update his will once he has written his. We have already discussed it before that a will can be updated and changed n number of times. See, births happen in the family, deaths happen in the family, marriages take place, divorces take place. So, all these events, we need to change or update our will. So, you can update and change your will n number of times. Also, a person thinks that he would no longer be paying debts if he is gone. So, this is also a very big misconception. These debts, you'll have to clear them. But these debts would be cleared according to the court's wishes. The courts will say that please auction or sell so and so asset of this person and give the proceeds to the creditors. And then, in that case, the court may advise or may direct the selling of a set which you may not want that it should have been sold. So, in that case, it is always recommended that you choose what all assets your debt should be paid off of. These are in your hands, and everything can be easily taken care of when you make a valid and legitimate will. A question that is very frequently asked is, when is the correct time to make a will? So I would say that the best time to make a will was yesterday. The next best time is today. So make your will today and secure your legacy. Thank you. Now I would like to hand it over to Sunil.
Yeah, most of our experiences and learning about wills are probably from Bollywood movies where we saw many of these scenes where people lie on the deathbed and they're talking about well. That's absolutely false. So don't go by that misconception. And we're not saying this to get new customers. I firsthand experience some of these pains. If there is nothing like will, and I know the pain and I know the suffering, and that is the reason I quit my job and I'm doing this for full time. So myself, Sunil, I'm a certified CTO from ISB Exec Alumni. I have 20 plus years of experience in software industry. Vaishnavi is a senior lawyer. She has 5 years of experience in multiple legal areas, and she has a master's degree in constitutional law as well. She is my co-founder, and the reason why we are bringing this platform is to help democratize estate planning in India. What do you mean by democratizing? So a lot of there was a question also about the will pricing, how costly it is, how easy it is. We want to make it easier to uh, purchase, easier to manage the data, easier to procure a will, easier to manage this estate planning. And that is the reason why we are building this platform. And this is very easy to use kind of platform. And because you took your time out on a Thursday evening just before a couple of long weekends, there is a vacation which is coming, Gudi Padwa, Ramzan, all of this, and yet you took your time in the evening to attend this, and that is why we want to show our gratitude and offer this our platform for a discounted price. Before that, I just wanted to just let you know that the platform is built in a secure way. Trust me, I come from a banking background. I worked in a European-based premier banking industry, so I know how data is very important and critical. How we need to safeguard it. So we built these into the system. System is absolutely secure. Your critical information, critical documents which you are going to put into the platform for the will or any other services is going to be absolutely safe. You can choose to share this with family or our legal team when the time is right. For example, you want us to prepare the will, or you want us to help with the will preparation. That is the time you can share this data. And this is an absolutely affordable platform, and the platform costs no money. You can, even today, you can just sign up. You can use the platform without availing any of the services like will writing or any other services. Platform is free. We will only be charging for a specific service. For example, you want us to write your will, that is a charge. You want to write as a gift deed document, that is a chargeable thing. That is how we are positioned. And as I was mentioning, because you attended this, we want to show that gratitude. And we are offering will writing at a cost of 1500. That is plus 1500 plus GST, which comes to around 1760 or something. If you scan this QR code, you will be shown a payment page where you can put in your first name, last name, mobile, email. You can purchase this. And as soon as tomorrow, you will get your login credentials to use the platform. It is a very simple, intuitive app we have built, which is easily accessible from both with laptop, computer, or mobile device as well. And you can start with your will journey. This is a limited period offer. It is only valid until 30th March. So please do take this opportunity and pass on this benefit to someone else you think also deserves this kind of thing. Although they may not have attended, you could definitely share the recording once we share it with you, so that they can also get benefit from you. So helping your friends and family is also kind of a good deed. You should definitely do it. So saying that, I will move to question and answers. I think Vaishnavi, you can look at the question and answers. I did try to answer some of them. So coming from the top, can we nominate a minor in our will? If so, what is the procedure? This is asked by, I think, Vasavi. Yeah.
Yes. Yes, so definitely you can nominate a minor in your will. A minor can be definitely a beneficiary in the will, provided this whatever you are passing on to the minor, it will be in his individual name only when he turns 18 years. So we also need to mention the name of a guardian who would be the custodian till the time the minor turns 18 years. So definitely a minor can be a beneficiary under a will. Second question we have is, can we make changes in our will later on? Definitely you can make changes in your will n number of times. There is no limit to that. Next question is, what would it cost to create a will for a family who has basic info like couple of bank accounts, one independent house? So, will creation does not depend upon the number of possessions you have. It depends upon the service charge that we charge or any other person charges.
And just for your information, so this will charges, right? It can be anywhere from 5,000 rupees to 15,000, 25,000. There are esteemed lawyers who does this for a very, very costly price. There are some lawyers who does it for a cheaper price, because we are a platform, because we are building automations, because we are lean team, because our core business is not around wills. We want to help and more than wills, and that is where our will pricing is much cheaper compared to anyone else. Yeah.
Next question is, can we write in the will like if after Mr. Bond is not alive, then his things will go on to his wife, Mrs. Potus, and if somehow Mrs. Potus is also not alive after Mr. Bond, then the property will assign to niece Miss Neela, a far relative or non-relative. Definitely, you can put in n number of possibilities in your will. It is in your hands how you want your assets to be disposed of. Would it
This is answered already.
Yes.
Yeah, this is answered. Yeah. And question
Uh,
4 is also answered.
Yes.
It is
Yes.
very first. Yeah. Next question is, what if beneficiary
Yes.
loses their life by any unfortunate situation? In will, can we mention multiple beneficiaries in preferential order? Yeah.
Yes. Yes, you can do that.
Okay. And the next question is, I miss you. Why one is allowed to revoke will multiple times? A revoked will, how will it get into effect again?
So you can revoke your will n number of times because life changes. Some conditions are there, like you made a will, but another birth in the family took place, or somebody whom you had named in the will lost his or her life before you. So in that case, we need to make changes in the will. We should always keep on updating our will, and how will it get into effect? You need to revoke your earlier will. Like I said, when you are making a new will, we always write in the beginning that hereby I revoke all my earlier wills and testaments. Like this, you revoke your earlier will and make a new will.
Okay. Vaishnavi, can you share that QR code one more time and just drag that sharing button down, because I think QR code was not visible for the full time. We
One
can put in that
second.
one more
Yes.
time. And don't worry, immediately after you close or log out of this webinar, you will be redirected to that screen. If you want to bookmark it, if you want to copy paste it, that is also possible. So put it in the presentation mode so it is easier, and just hide the sharing screen button. Yeah, yes, hide. Yeah, okay. I hope this is visible now. So the questions are done. So I can open the floor for any follow-up questions. If anyone has any questions, they can raise their hand using gestures. I can enable the voice for them to let me know. And we will be sharing this video recording with all of you.
Any question, any clarification you want from our side, any point that you missed out or did not understand? You want to share some experience of yours or anything? Please be free.
From the poll result, I do see many of you already took a term insurance, right? See, that is the kind of driver also to think about well. You wanted to protect your family in case something happens to you. That's what term insurance does, right? That is that is a simpler version of what you want to do with your family after you're no longer there. But if you think about many other things, that is what will helps you. So it ensures peace of mind. It ensures everyone has their legal rights over the rightful assets or properties. So protect them, secure them, don't let them get into any kind of legal troubles, and you can execute your wishes as per your will, and you can write your wishes into your will. So that's how will is going to help you, and it is a simple thing to do, but it goes a long way if you does that. If there are no questions, we can close the call. But if someone has any questions, do raise their hand, and or maybe perhaps question and answers as well. Okay, so I will enable voice for Ruchi. Okay. It should be connected. Ruchi, I think you can unmute yourself and talk. Ruchi, you have to unmute. I enable voice.
Audible?
Yes, yes, you are audible. Yeah.
Yeah. Okay. So my question is, in India, is it still that only the sons get the property and the daughters don't get? Is it something like that, or both the kids are liable for the equal property? Like,
Yes, now the daughters also have an equal share in their father's property. Also, when we are talking about wills, so it is in your hand. Maybe you can choose to give your entire property to your daughter and give nothing to your son. Therefore, because once a will is in place,
hmm,
the disposition of property will take according to the
what?
desires of the testator. In that case, the succession laws will not come into play. So,
Oh,
whatever the things are there in the will, the property would be disposed of according to the wishes of the testator only.
oh. So if the bill is already done, like we have to follow that. If
Yes, yes.
not, then we
Then
can see the
succession
law.
laws will come into effect, and whatever these succession laws are there according to your religion. So, whatever these succession laws are there, the property would be disposed of according to these succession laws only.
Okay.
The shares are already earmarked in these succession laws as to who will inherit what.
Okay. Okay, ma'am. Thank you.
Okay. There are a few more questions in the Q&A. I will read them out, Vaishnavi. So would you be sharing the presentation as well? We will be sharing the recording. If you feel the presentation has a lot of value, we could share that. But I believe most of this content which is there in the presentation, that is available in our website as a blog entry as well. There are a couple of blogs which are especially written on debunking the myths and why you should have will. You should definitely go through that because presentation is a summary of those blocks. What other legal services are being offered in the platform? Are your services location dependent or services require sub-registrar office? So the way the platform works is we are only offering all the inheritance related services, which means anything to do with property giving away to your next of kin beneficiaries. It could be testamentary and non-testamentary in terms of gift deed, which is an executed when you're present. Those kind of things are also there. So what we want to specialize in is not just about a will gift deed. We want to specialize in the post demise entire claim settlement. The way we are building this platform is to help individuals to claim the assets without much of a fuss, because most of this process is offline. It is broken. You need to visit banks, you need to visit insurance provider to submit a lot of documentation. In case of some complications, if there is no legally valid will, there are multiple runs you need to do. You need to approach court to get a succession certificate. All of this we want to avoid, and we want to put this in a framework in a proper way, so that post demise settlements are much easier, much faster, and it is less burden. You don't need to pay anything, because the way we are working on this platform is we have created two different plans. a basic one and a comprehensive one. Based on the coverage of these plans, entire legal or administrative expenses are covered from our pocket because you're a subscriber to the plan. That is how we operate. You can check more details on our website, yourinsured.com/services. That is where you will find more details on what exactly are the complete list of services or plans. So,
Also, I would like to add,
yeah.
these services are available pan India. We have a network of lawyers. So, in case you need legal representation in courts as well, we put you in touch with those lawyers, and everything is taken care of all over India.
And the follow-up question was also same. What are the services you provide? Yes, that is answered. In term plan, Mr. Bond has nominated voters, but in the will, Mr. Bond has nominated Mrs. Neela. How this will get executed? You want to take up this question?
Yes. So, like I said, nominee is there to temporarily take care of the asset. The actual person is the beneficiary. So, once you have a will and a beneficiary is named, and you get a probate from the court, the asset is actually transferred to the beneficiary. So, you need to submit the will and the probate to the respective company, or say from the person whom you have taken insurance. In that case, this very person who is named as a beneficiary in the will actually be inheriting the particular amount.
And just to clarify, right, nominee is only acting like a legal guardian to that asset or bank account balance until the rightful heir comes and claims. For example, you can put anybody's name as a nominee if he is not a legal heir or not a rightful heir. He or she should not actually take that money. That is how court looks at it. Okay. And we want to also simplify this problem. The nominee update, sometimes we doesn't do it on time. When people pass away or when people are no longer there, we keep the same old name, and this creates a lot of troubles as well. And trust me, I know this problem very well. And that is why in our platform we want to help with nominee updates as well. Currently we are trying to work with multiple different digital insurance players, banks, all of these guys to uh, put this functionality into the app itself, so that you can update the nominee from within the platform. You don't need to do that from outside. But a lot of these internet banking and mobile banking apps already provide that. So it is always advised to keep your nominee name updated as frequent as possible. If you need someone to be reflected the right nominee, you should definitely do that. Yeah. The next question is answered. Can I create an encompassing will, meaning all my belonging will go to my wife or kid after me, or should I explicitly list them in the will? Vaishnavi.
You should explicitly list all your properties and whatever you have in the will. So, like I said, you cannot simply write that all my things would be passed on to my wife. You should first write down what all assets you have, and then you should write down that all these assets would be passed on to my wife.
It could be beneficial to the family as well. So for example, if they want to know what are the properties, if that
Yes.
list is not with them, if they don't know how many properties you own, this is probably the right time that they know, right? And if you say all properties, they would probably know only few of them. It is very common for husbands to uh, keep some of this data secret. I mean, um, not entirely secret, but sometimes you may not know the entire details. What exactly is the address of this? Where is the document for this? All of these details may not be available. But if you list them all down in the will, that would be more beneficial at the time of execution. It would be easy. Yeah. So will you be sharing the recording and slides of the webinar? As I mentioned, recording definitely. Slides, as I mentioned, this is a synthesized slides from our blogs. So you can visit our blogs. They are listed in the website yourinsured.com. Do you validate the credentials of testator, especially the details being discussed in a will? Vaishnavi?
See, when there are two witnesses and they are there only to validate that the testator has actually voluntarily signed the will freely. There was no force, there was no coercion when the person was signing. This is the duty of those two attesting witnesses. Whether the attesting witnesses need not know what the person is signing, need not know the contents of the will. So a person may put in some property which he no longer owns, but that is not to be validated by those attesting witnesses. They are only validating that the person has truly signed the will in their presence out of his own free will.
I hope that answered your question. If you have a follow-up, you can raise your hand, Vikas, and I'll just move on to the next question. Can I write will on my inherited property like an ancestral one?
uh, for that we have to look into like what property you have, because inherited property is generally divided amongst all the family members. So you cannot property that you have inherited, you cannot give it only to a particular person, because automatically each of the family member has his or her share. Obviously you can write down up, uh, you can choose to inherit only a part of your particular share, but not the entire thing, because all your family members have a part of theirs in that inherited property. So the entire inherited property you cannot give it to only one person.
Let's say as an example, if he or she inherited the whole property, can he or she write about that property in the will?
No, you cannot, because automatically if you have like two children, both of them will have a share in that property. If you give it to one children, the other children can definitely contest for his share in the court of law, even if you have written it in your will.
Okay. So inherited property, you have to share it with your next of kin.
Yes, yes.
Okay. So last question, what if the will proposer had registered his will long years ago and had given all his or her share to his or her sons? The will proposer is no more now. Can the daughters claim their right in the property now?
uh, if the property was self acquired property, that is, the property was actually purchased by the testator, then the daughters cannot. But if it was an inherited property, then definitely the daughters can.
I hope your questions are answered, Vikas, Parikshit. If you have any follow-up questions, do raise your hand. I can enable the voice if you have a follow question. Okay, so there is one more. 1500 plus GST is the price per property or per nominee, or is complete cost for the will? It is complete cost for the will. It is not per property or per nominee. It is complete cost of the will. Okay. Any other questions? Okay, great. Well, thank you. Thanks a lot for joining the call. I hope you learned something valuable. Where is your office located? We are based out of Pune, Vasavi. We are based out of Pune. I mean, startup is registered in Pune, Maharashtra. Okay, there are a couple of comments on the chat. I would just go through. Yeah, what service you offer in basic plan? Um, uh, Parikshit, I would advise you to just send a chat request in the website, or you could write to info@your ensure.com. I could definitely help you. That is listed there in the website under the services, our services. If you go to that page in the website, you would see what is listed under the basic plan, what is listed in the comprehensive plan. At a high level, what I can say is comprehensive plan is a little bit more exhaustive, like the property transfers, vehicle transfers, your EPF loan transfer, EPF claims, and everything is included, including the probate and will execution. But if it is basic plan, it is mostly about probate. Will you can do the will changes number of times, nominee updates, and digital claims. Digital claims in the sense bank account claim settlements, insurance claim settlements, and investment account claim settlement. All of these are included into the basic plan. So there is one more question Manjiri posted. Okay. If a property is not listed in will, is inheritance law applied to it?
Yes, then that property will pass on according to the Succession Act. So again, you'll have to go to the court and get a succession certificate, and then that property would be distributed according to the rules of succession that are there in according to your religion. So for Hindus, we have the Indian Hindu Succession Act. For Christians and Parsis, we have the Indian Succession Act. For Muslims, it is the Muslim personal law. So if you do not mention a particular property in a will, then that property would devolve according to your religion, the rules of your religion.
I hope that answered your question. If for any of your questions, if there is a follow-up, you could raise your hand and you can speak. Otherwise, you can always reach out to us through our website. You can initiate a chat request or submit a questionnaire info, or you can write to us. Our contact details are available in our website as well. You can call us, write to us, WhatsApp, anything. Reach out if you have any questions. Okay, I'll stop the recording. Thank you everyone for joining, and hope you had a good understanding about